Kingston Bookshop.
The people's champion. Our mission is love. Our vision is love. Jamaicans for justice. The people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Justice, justice for all. Justice under the law. Justice, the people demand. Right to life and security. Oh, what a joy. Oh, what a peace. How great this country could be. Respecting your rights. Respecting human rights. What a wonderful.
Happy Monday. It's a beautiful day here in Kingston. My name is Michael Jackson, Executive Director of JFJ. And just saying thank you to our listeners who continue to join us and support us on the radio show. Special thank you to those who are listening in on radio, those who are joining us here via the nationwide YouTube platform, and those who are on the JFJ's YouTube platform as well. Thank you ever so much. I'm flying solo here today because my co-host Jade Williams is off on a short break. So you will be with me alone. But we're going to be discussing some interesting matters that came out of last week's sitting of the House of Parliament. And that is the matter of mandatory minimum sentencing. While I will give a good overview of what that entails and what Minister the Honorable Delroy Chuck articulated, we're going to be focusing primarily on the matter of children and the implications of the mandatory minimum sentences for them. And to discuss the topic, we're going to be joined by Kimberly Cox. She is an attorney at law, but legal consultant for Free Children Foundation, which is a youth-based non-profit organization. All right, so that's the topic for today, the matter of mandatory minimum sentence. Before we get into today's topic, last week was a busy week for the organization. As you are aware, we had our End Police Violence peaceful protest last week, Tuesday, in the Halfway Tree vicinity. And we made our calls around the concerns that we have with the increasing number of police fatalities that we're seeing in the country. And we've also made some calls in terms of things we would like to see fast-tracked, which includes the wearing of the body-worn cameras in certain situations. Also, the fast-tracking of the procurement process for the body-worn cameras. And I will make some clarification and just a point of information as we go through for the next few minutes. So our calls in Halfway Tree, which is what we've been saying, the numbers are far too high when you compare it for the corresponding period of last year. And we've seen where the police fatalities have more than doubled, at least 2.5 times what it was last year this time. So when the organization speaks, you will see us saying, for example, when we tally the numbers of the police fatal shootings of this year compared to last year this time, you will hear the percentage jumping or varying, 140% increase, 165% increase, and so on, depending on where we're at in the year. And while we have never said that these are extrajudicial killings, because remember, we still await the reports on the investigation, the matters have not been ventilated before the courts. What we have articulated is that these sharp increasing numbers require greater scrutiny. Outside of the numbers themselves, why do we say it requires greater scrutiny? 40% of the fatalities last year, 2024, were as a result of planned operations. In other words, planned operations contributed to 40% of the fatal shootings. So if you tally 189 fatal shootings and you compute 40%, you're talking about, just rough math and speaking from memory now, that's about 76 persons who were killed following planned operations. And again, none of those incidents had a body-worn camera, which is why the organization has been speaking so stridently on the matter. When you look at other incidents, for example, those involving persons with mental illness, there were 10. Now, you may find that an action involving a mentally ill person who perhaps waving a machete around is of risk to both the police officer and the family member in one incident I remember. And therefore, the shooting itself may be deemed lawful based on the threat that was there at the time. But we ask ourselves, what could we have done differently? And what can we do differently in those situations to prevent the loss of life? I've spoken to police officers myself and during trainings. Based on INDECOM's report, best practices, it's important that our officers in some of these instances, they've articulated the need for greater training, how to deal with persons with mental illness. But more importantly is the community response when you have such incidents happening. What can we do differently again? How do we ensure that when a police officer responds to those incidents, you have mental health experts assisting in responding to those matters? Those are some of the calls that the organization JFJ has made, and others. Now, following the protests last week, we had a very cordial meeting with Police Commissioner Dr. Kevin Blake and members of the High Command. And we received some updates on the procurement of the body-worn cameras. We were told that they are near completion with a procurement of 1,000, and another 3,000 will be procured, I believe 1,000 per fiscal year. The organization will be watching closely and monitoring how soon the procurement will be finalized so we can have that added 1,000 body-worn cameras. The Jamaica Constabulary Force had put out some communication some time ago where it articulated that the data storage infrastructure needed to be strengthened. But what was not clear was a timeline within it. Clarification was had in that meeting that the data storage infrastructure has already been strengthened, and therefore the Jamaica Constabulary Force was speaking about in the past, but the efforts for the past 3 years, I believe, if I'm quoting Dr. Blake correctly, would have resulted in the strengthening of the data storage. So in other words, the added procurement would face no challenges because the infrastructure is there. So it is good that the JCF clarified that particular bit of communication. The other thing that was clarified in that meeting is where the body-worn cameras are deployed. And some of this we knew before. The beat patrol officers, the P-step, where you have your officers who are, dealing with traffic offenses and so on. Because those are everyday matters where persons may allege that there is some negative interaction. So you need the body-worn cameras there. No two way about it. And we agree. However, again, we need probity. And this is where our advocacy will continue. One, when we look at the incidents within which some of these fatal shootings occur, again, there were no body-worn cameras. And remember, 60% of them were not planned operations. So we will reiterate our call that when the added 1,000 body-worn cameras are procured, we need to also look where those fatal shootings happened and ensure that the body-worn cameras are so deployed. We've had incidents of fatalities happening within communities that were declared under SOE, under the zones of special operations. We've spoken here at JFJ about an incident where the person alleged misconduct by JDF officers, where he said he was beaten, but because of the wearing of the balaclavas, he was not able to identify the specific officer. Remember, under the Zones of Special Operations Act, it does say that body-worn cameras are to be worn as long as the resources allow. That's the law. So what we will be calling for is increased deployment of body-worn cameras in sensitive communities, especially those where we know there have been historic low trust levels between JCF and citizens, as we build transparency, accountability, better citizen relations. That is a call that we will continue to make. I want to thirdly say that JFJ, we make our calls from an informed perspective. We've had the privilege of speaking with security experts locally, internationally. We've toured other jurisdictions where body-worn cameras have been deployed. And I hear the JCF, the Minister of National Security, saying that in some of the high-risk incidents, the body-worn cameras that they have now would not be appropriate. And with that in mind, our advocacy going forward will be very clear that the procurement of the appropriate body-worn cameras for those planned operations should be fast-tracked because, again, you have 40% of planned operations resulting in fatalities. That's 76 lives, where in some of those instances you have contradicting and conflicting accounts between the officers and civilians. And we will be reiterating and strengthening our call for the procurement of appropriate body-worn cameras for those planned operations. So again, very good meeting generally, and our advocacy will reflect positions that we've had, and we will watch what happens with the procurement of the body-worn cameras going forward. All right, so we're going to take the break, and then when we return, we go into the trivia. I didn't say that earlier. I will state the trivia after the break, and then we start the conversation with Miss Kimberly Cox.
A mother's journey of love shared from generation to generation. Give her the ultimate relaxation and escape to Adam and Eve Day Spa and Salon for a mommy-made new experience this Mother's Day, Sunday, May 11. Book now at www.adamandeve.dayspaja.com. Purchase gift certificates or call 876-754-6017. Get mom the perfect gift of love. This Mother's Day, let Team Adam and Eve take her on a spa journey. She deserves it.
Big news! The Big Bite Food Safety Show now airs on Nationwide 90 FM with your host, Allison Richards, the Food Safety Girl. Join Allison every Tuesday from 1 to 2 p.m. as she serves up expert advice, tips, and insights on everything food safety. Stay informed, stay vigilant, and remember, food safety is everybody's business. Don't miss a bite of the action. Tuesdays at 1 p.m. only on Nationwide 90 FM, the new revolution in media. On the next episode, we go behind the produce stand. Safe, fresh produce vending in Jamaica.
Welcome back to Let's Start Justice. We're discussing the matter today primarily on mandatory minimum sentencing and its impact on children. And we are calling for urgent reform and, well, a rejection rather, because I think we have repeal here, but we can't repeal what has not yet been gazetted. So a rejection of what is being proposed, and I believe what was passed in the House of the upper house last week. But before we get into the show, the trivia question for this week: when did Jamaica ratify the United Nations Convention on the Rights of the Child, which outlines international standards for the treatment of children in the justice system? So when did Jamaica ratify what is commonly called the CRC? That's the Conventions of the Rights of the Child. All right? When did we ratify that? And the did you know, which we're going to be touching on during the program, did you know that under Jamaica's current Child Care and Protection Act, children as young as 14 years old can already be sentenced to life imprisonment? But under the proposed amendments, they could also serve 30 years with a minimum of 15 years before parole eligibility based on the particular offense that they commit. And I think it's important that we're aware of what this sentencing already outlines. So we're joined by Kimberly Cox, attorney at law, legal consultant at Free Children Foundation. Good afternoon, Ms. Cox. Thank you so much for joining the show.
Good afternoon. I'm happy to be here. Thank you for having me.
Really appreciate it. And before we get into the conversation, Ms. Cox, for those who are listening, just to remind you that the age of criminal responsibility is age 12. So therefore, a child under the age of 12 cannot be held liable for criminal offenses. Can be subject to a civil suit, but not held criminally liable. So if you're between the ages of 12 and under 14 years old and you commit an offense, you can see yourself facing a possible term of no more than 25 years based on the offense that you have committed. 14 years old to under 18 years old, you already have the Child Care and Protection Act indicating that a child can be subject to life imprisonment. That is what the law already allows. So the law already allows that, Ms. Cox. I think the question I will first start out with, what exactly do you get from Minister Chuck and the government as to the reasoning behind what they are proposing?
Well, I thank you for that question. And let me just start off by saying that I believe that whenever we're speaking about children, we have to be cognizant of the fact that we're dealing with minors. We're not dealing with adults. So that is the first thing that we need to bear in mind. As it relates to my understanding of what Minister Chuck is proposing, my understanding is that there is in fact a proposal of a mandatory minimum sentence of 15 years for minors between the ages of 14 to 17 who commit murder offenses. That is my understanding of what is being proposed.
Yes, and let me speak here from Minister Chuck's statement that he read in Parliament. And I think it's important that I also make reference to what was first proposed before several of us went to the Joint Select Committee. JFJ, we made our proposals and recommendations there. So too did UNICEF and Jambar and other entities. So what is being proposed, and I read here from Minister Chuck's statement, Ms. Cox and listeners. For the Child Care and Protection Act Amendment Bill, it seeks to amend Section 78, subsection 3, so that notwithstanding the provisions of the Parole Act and the Offence Against the Persons Act, on sentencing any child for the offence of murder, the court may specify a period of not less than 20 years which that child should serve before becoming eligible for parole. That was before. That's the first iteration of what was being proposed. The proposed position now, following robust discussions, is a bit more nuanced. The proposal is that if the child is convicted of capital murder, remember capital murder is where, for example, if someone kills a member of the judiciary, like the judge, a witness, a juror, then you will be, or multiple murders, you'll be subject to capital murder. So in that instance, what is being proposed now is that the child shall be sentenced to a term of imprisonment for life, which already exists, or to a term not less than 30 years. However, the child will be eligible for parole after serving 15 years. All right? So it's twofold. If the child commits capital murder, he shall be sentenced to a term of imprisonment for life or to a term not less than 30 years. However, will be eligible for parole after serving 15 years. If the child is convicted of non-capital murder, he or she shall be sentenced to a term of imprisonment for life or for such other term as the court considers appropriate. The court will have the latitude to determine the years that must be served before the child becomes eligible for parole. So I've just read to you, Ms. Cox and listeners, what Minister Chuck is proposing. In response to that, so just to clarify, remember it was a term of not less than 30 years or life, but the parole eligibility is the 15 years for capital murder.
Right. So our perspective here at the With Children Foundation is that we want, firstly, to always appreciate that judicial independence has to be observed. Mm-hmm. We believe that when it comes on to dealing with children, when it comes on to dealing with minors, the same type of penalties that they would incur should not be the same type of penalties that adults would incur. Mm-hmm. So as it currently stands, if we do decide to impose such a mandatory minimum sentencing period of the 15 years prior to being able to be eligible for parole, all that will do is to require and mandate that once a minor commits such an offense, a capital offense, then they immediately, notwithstanding their circumstances, notwithstanding their vulnerabilities, notwithstanding the violence that they have been pre-exposed to in their communities, they would automatically be remanded in prison for at least 15 years, right off the bat.
Yeah.
Now, our position is that cannot be just nor fair to children. There is no way that we as a community, we as a society, can be imposing the same types of penalties, the same types of perspectives that we would have for an adult on our children. Mm-hmm. I believe that what we need to do as a society and as a community and as a government is to try to focus on what is the root cause of our children engaging in violence. The reality is that our children are more predisposed to violence than any other subset of age groups. The reality is that the children, particularly boy children, they are the ones that are being targeted by gang members and by gang violence. It is not the elderly who are being targeted. No.
And I'm happy you said that, Ms. Cox, because here are some nuances that I think the legislation or the proposed, I would say proposed bill, but what that is, the anti-gang legislation, interestingly enough, makes provision for a child who may be subject to the influence of a gang leader. For example, a notorious gang in a community that forces the child to do a particular act. The anti-gang legislation allows for that, facilitates that child being treated in a specific manner. So the question is the proposed amendment here not considering that particular nuance that I just outlined following your commentary earlier?
I would 100% state that I don't believe that we're aligned with our international obligations, with the current legislation that we have already in place when it comes on to this new proposal. I do not believe that we're aligned. And I believe that Jamaica, who is a signatory to the Convention on the Rights of Children, we need to be more mindful as it relates to these proposals that we are bringing forth. Mm-hmm. We need to be more mindful. We're not in alignment.
Yeah.
We are not.
And, another thing, Ms. Cox, which is why unique consideration or judicial consideration for unique circumstances or a case-by-case basis is appropriate. because I'm seeing some of the listeners and a few WhatsApping as well indicating but capital murder is serious. But take, for example, an incident where a child, not saying that committing any unlawful act is something to be celebrated or given a slap on the wrist. But say, for example, a child who goes into a house to commit an act of robbery and a murder happens in the course of that robbery. I'm not sure if we are aware that in such situations it will give rise to the threshold of capital murder. And the question is, what would be the judicial discretion for such a situation? Is it a case where a child who perhaps goes out and kill 3 persons would be treated the same as the child who went to commit an act of robbery and an accidental death happens? Ms. Cox.
I believe you have raised such an important point that we have to address. The reality is that as it currently stands with non-capital offenses, judges have the discretion to allot the appropriate sentencing that they deem fit. I believe, and we believe here at the Children Foundation, that that is what should remain even as it relates to capital offenses. And the reason for that is because there is a reason why there is a separation of powers between the legislature, between the executive, as well as the judiciary. We believe that when it comes down to the judiciary, there is a reason that they have their own discretion to decide the appropriate sentencing for children, because they will determine what are the unique circumstances to take into account. And I believe that the reality is that indicating, or rather mandating, a mandatory minimum sentence removes that judicial discretion completely. It completely removes it.
What I will say, JFJ's position is that the Child Care and Protection Act ought not to be amended at all within, the current discourse that's happening. No mandatory minimum should be applied for children. But I can say to Ms. Cox and listeners that even what we're discussing now is a revised version of what was when it went before the Joint Select Committee, because that particular section in the Child Care and Protection Act, Section 78, subsection 3, that's where judicial discretion is when it comes to the sentencing of children. The first iteration of this particular bill sought to remove that section altogether, Ms. Cox. But at least we're seeing some reinsertion of it when it comes to the non-capital murder and other offenses. And that's something, again, we can say thanks to Minister Chuck for listening, but we still have some concerns, significant concerns about the capital murder component where there is the mandatory minimum sentence there.
I have to agree with you. I completely agree with you. And I believe that, as I had indicated before, we need to focus, I believe, as a society and as a government, on the root cause of violence, the root cause of youth involvement in violence. And I believe that we should instead be focusing our attention when it comes on to child diversion programs, rehabilitation programs, educational programs to get our youth off of the street and to focus more on their future. Because I believe as it currently stands,
Ms. Cox, hold that thought for me, and then when we come back from the break, I want us to pick up on the rehabilitation and the child diversion.
Of course.
For generations, Jamaican families have trusted Imperial Optical to keep their vision clear and their style sharp. From their first eye exam to the latest in fashion frames, we've been there for every milestone, every moment, and every memory. Whether it's your child's first day at school, or your grandparents' golden years. Our care spans every age, every stage. Visit Imperial Optical today. Generations of care, generations of trust.
Get ready for a heartwarming and inspiring celebration as E-Zone honors the dedicated heroes of education on Teachers' Day with a special live outside broadcast from Lorna Auto Prep School. Join us on Wednesday, May 7 from 1 to 3 p.m. as we recognize and celebrate the teachers who shape minds, build futures, and inspire greatness every single day. So don't miss it. Celebrate Teachers' Day with the E-Zone and Lorna Auto Prep School on May 7 from 1 to 3 p.m. Catch the live stream on Nationwide 90 FM's YouTube channel at Nationwide 90 FM Live 2. All this and more only on Nationwide 90 FM, the new revolution in media. This broadcast is brought to you by Chris and Charles and JT Cooperative Credit Union.
Welcome back to Let's Start Justice. We're discussing the mandatory minimum sentences that are being proposed with a particular focus on children. And we're joined by Kimberly Cox, attorney at law. And before the break, Ms. Cox, you were focusing on the importance of rehabilitation and the child diversion. I'm seeing some pushback saying that are we promoting a simple slap on the wrist for children, even when they commit serious offenses?
Well, I can completely understand why the public is worried about that. Because when it comes down to violence, it touches and concerns each and every one of us as a society. We are of the view that no child should get a simple slap on the wrist once they have committed a heinous or serious crime. That is not what we're proposing. We do believe that there needs to be punishment, but it is just a question of the type of punishment, and also it is also a question of us trying to address the root cause of the issue. Mm-hmm. I fear that as a society we have a tendency to look at the after effects as opposed to looking at what started the problem in the first place. We are not proposing that there be no punishment at all. No, that is not what we're saying. We're saying it is just the effect of the punishment as well as the type of punishment. Mm-hmm. That is what we're focusing on as a society.
And who issues it, importantly, because, again, the courts are best positioned to impose a sentence because they are looking at the unique circumstances of that particular matter before the courts. Because what people perhaps may not readily appreciate is that the parliament is tying the hands of the courts. And I think you started your commentary by indicating that the importance of separation of powers can't be underestimated when we're talking about the justice system and judicial fairness. So I'm happy that you mentioned that as well. But to the point of rehabilitation, Ms. Cox, and child diversion, how do you see that within this particular context and conversation, and how exactly, in your estimation, this particular proposal may be undermining those particular piece of legislation and concepts?
Well, I thank you for that question, and I think the answer to that is very clear and it's very simple. It is almost as if we're applying a black and white rule. Meaning, if you fall within a particular category, you have conducted, you're guilty of a particular offense immediately, without questions and without consideration for the realities that you had to live in, without consideration for the violence that you've been pre-exposed to, without consideration for the community that you come from, without consideration for the fact that perhaps you were recruited and perhaps you were forced into violence by gangs, without consideration for any of the above. Immediately, you are remanded. Immediately, you are forced to suffer a penalty. It's a black and white application of the law. Mm-hmm. And I believe that the law is never black and white. I believe that there are always gray areas that have to be considered, which is why the judiciary has a certain level of independence when it comes down to analyzing and also interpreting the particular circumstances of an individual. Everyone's situation is different. what a child may be exposed to who lives in a particular community, who is surrounded by a particular subset of people, who sees nothing but these subset of people, who sees nothing greater than the life that they're exposed to. What do you expect to happen with them? They're not necessarily always going to choose a better path. And I believe that the judge is the one who should have that type of a discretion to decide what type of a sentence they should get. We're not saying they should get no sentence, no. We're saying leave it to the judges because they are the ones who know how to analyze these things.
Thanks so much, Ms. Cox. I know we're discussing the matter of children, but I just want to ask you a question on judicial discretion by just outlining generally what the other aspects of the proposed amendments include. So for capital murder, which we know currently what obtains is life imprisonment or the death penalty. But we know the situation with death penalty there. It's what is being proposed is that the period for parole for parole eligibility would move from 20 years to now 50 years. What was proposed before to what is being proposed now, the minister and the Joint Select Committee has lowered some of the mandatory minimum penalty. So what is being proposed now for non-capital murder is 30 years instead of the 45, right? And where a term of years has been imposed, the period that must be served before eligibility for parole is 20 years instead of the 35. So it's moving from 10 as currently obtained in the Offence Against the Persons Act to now 20 years. And that's a fixed term period. So just generally, Ms. Cox, when you listen to this, capital murder, 20 to 50, non-capital, now 30 years, and then for a fixed term, from 10 years to 20. How do you respond in terms of the importance of the courts, just generally, again, within this context of what we're discussing?
I believe that the perspective I had shared earlier still maintains. And I believe that there's a reason why the judges have their discretion, and there's a reason why we have separation of powers, and that there should be, in fact, judicial independence in that regard. I am not of the perspective that the government isn't trying to do what they can to reduce the level of violence. I believe that that is their goal when it comes down to this increasing of the mandatory minimum sentences or just changes overall. But I still maintain that the judges should be allowed to have their judicial discretion for a reason. I believe that constitutionally, I believe that as a country, we have this level of independence for our judges for a reason. And I don't believe that that is something that we should necessarily be so quick to change, or even if we do, we should be careful in the way that we do it.
Yeah. You know, this particular bill, apparently, it was shared with the wider parliament the evening before it was to be debated, after 5 o'clock. And these proposed amendments will have far-reaching implications when it comes to things like prison overcrowding. And I've heard the public commentary that says that if that is a concern, why not advocate for just building another prison? But it's more fundamental than that, as you've articulated, because if it is that we have parliament, and it's not even parliament in its entirety, the executive, by way of its cabinet, came to a decision. I can't say that they listened to some of the public commentary, but most of the public commentary had said, listen, don't move ahead with this. So the executive, by way of its cabinet, went with what they decided. Then it went to Parliament. There wasn't robust discussion because, as I just said, it was the evening before and it was passed the day after. So what's the purpose then of governance is my question and my concern. If the courts are simply there with their hands folded, just rubber stamping ultimately what the cabinet has decided is the concern. But I will leave it to you, Ms. Cox, with a last word on this issue as we close out this part of our show.
Thank you for that. I just want to remind the public that at the end of the day, we're a society, we're one, and we are to live as a community. I want to also remind the public that when it comes down to children, there is way more than meets the eye. I want to also remind the public that when we're dealing with children or minors, we have to remember that they are the future, and it doesn't mean that they should go without punishment for committing heinous crimes. It just means that we need to be careful in the way that we're dealing with them and how we address the root causes leading them to violence. We're more than violence as a country. We always have been, and I hope that we remember that in the future. Thank you.
Thank you so much, Ms. Cox. That was Kimberly Cox, legal consultant with For Children Foundation. I appreciate you joining.
Thank you for having me.
I'm seeing some of the comments here that the term of imprisonment should be 100 years, and it should not be in the favor of the offender or the perpetrator. And I don't think that's what advocates and attorneys are articulating, that again it should be a slap on the wrist. What we're saying is that let us look at what currently obtains in law. As it currently obtains, a child can be subject to life imprisonment. Ages 14 and older can receive life imprisonment. But what exists now is judicial discretion, where the judge can look at things on a case-by-case basis. We'll be able to look at the facts on person A and say, based on their social situation, the particular facts of that case, this is what I believe, in keeping in within context of the sentencing guidelines already there and so on. What is the just term of imprisonment for this particular case? So it provides some flexibility. Again, we have to go back to what the law currently obtains. And if we want mandatory minimums so high, then what is the purpose of the courts then? What you have are courts that are merely subject to what Parliament has asked them to adhere to, because the mandatory minimum sentences are so high. So just to put that in context, what currently obtains in law. And the other things ought not to be treated indifferently in terms of matters of prison overcrowding, matters of rehabilitation, matters of whether or not sometimes what is being proposed by the government and what currently obtains, if they are in conflict. And we see in some instances you propose a law, but you may find that it undermines what already exists. And I can tell you, one of the proposals that were being made was the matter of guilty plea discounts. And the Criminal Justice Administration Act and the proposals that were there would seek to basically get rid of that, because there's already another piece of legislation that deals with plea negotiation. For example, when you have some evidence as an accuser and you want to enter some plea negotiation with the Crown by way of the Director of Public Prosecution's office. But there was another component under another piece of legislation that this particular bill had undermined. And then you ask the question, what exactly does she mean by that? But when you look at the matter of entering a plea and you can get the discounts by the court, what it means is that the victim does not have to suffer through a lengthy trial. What it means is that you can have speedy resolution of matters. What it means is that you would reduce the court backlogs. And a reduction in the court backlogs means that victims, for example, victims of rape, can see their matters advancing much quicker before the court. So it's a lot to digest, but what we're going to be doing in coming weeks is just to see how best we can explain some of these implications. That is not a case where people want to see, slap on the wrist and so on. We have to look at the implications on the wider justice system. Fairness and just sentences must be imposed based on the particular circumstances. All right, so we take the break and then we return with some more discussions.
Sport Spring into style with Unique Living. Upgrade your home with our extensive range of products. Get sleek shower panels, stylish vanities, LED and non-LED mirrors, plus kitchen sinks, closet solutions, ceiling fans, and more. Available in various finishes and sizes. Visit shop number 630 Dunrobin Avenue, Kingston 10. Call 876-755-3661 or visit our website at www.uniquelivingja.com. Don't wait to spring into style with Unique Living.
Tune in to Nationwide 90 FM on Tuesday, May 6 from 2 to 4 p.m. for the live sectoral presentation by the Minister of Legal and Constitutional Affairs, the Honorable Marlene Malahoo Fort. You can also view the presentation on Nationwide 90 FM's YouTube channel at Nationwide 90 FM Live 2. Tune in to Nationwide 90 FM Tuesday, May 6 from 2 to 4 p.m. It's the live sectoral presentation by Minister of Legal and Constitutional Affairs, the Honorable Marlene Malahoo Fort. All this and more only on Nationwide 90 FM, the new revolution in media. This broadcast is brought to you by the Ministry of Legal and Constitutional Affairs.
Welcome back to Let's Talk Justice. We're about to wrap up, but just some interesting things that happened in the news cycle last week. We just heard a little ad there regarding the sectoral presentation that will be made by the Honorable Marlene Malahoo Fort, Minister of Legal and Constitutional Affairs, and that sectoral presentation will happen tomorrow, Tuesday. Now, there are a couple of things that we're expecting from the minister when she speaks. Certainly, we expect her to give an update on the constitutional reform process. How many proposals were received or recommendation report from different sector heads, agencies, and so on. And what has been the appetite from the Joint Select Committee regarding some of the proposals made so far. I haven't had the opportunity for the past few weeks to listen in on the Joint Select Committee sittings. I normally watch it, but I think it's important that we get an update on some of the issues that have been raised. I think there needs to be clarification in terms of the implications of the composition of the Senate, in terms of the proposal where you would see the president appointing 3, the ruling political party appointing 15, and the opposition appointing 9. Because while the 2/3 majority will remain for amendments to entrenched provisions, JFJ in our report or recommendation to the Joint Select Committee had raised a concern about that two-tiered, for lack of a better terminology, implications for the 2/3 majority, whether or not the 2/3 majority, which can be achieved with the 15 from the ruling political party, the 3 from the president, could see states of public emergency being extended without the parliamentary opposition's input. That is something I believe that the minister would need to clarify in light of public commentary, because we also raised it in our recommendation report to the Joint Select Committee. And if it is that it would have no implication at all for the extension of a state of public emergency, I can't imagine the justification, what mischief is trying to be solved by having that arithmetic exercise happening rather than just saying 2/3 majority and you must have a parliamentary opposition member for any matters where 2/3 majority would so apply. So I think that is something that the minister would need to clarify. I mean, there's some other things in terms of the concerns that have been raised regarding the election and nomination process of the president. I think there needs to be some clarity there, and we've raised some concerns from where JFJ sits in terms of the reserved and discretionary powers of the president. So it may not all be achieved in the sectoral presentation, but I do think some updates are needed there with the sectoral presentation coming from the minister. All right. There are two other things. I'm hoping I can put them in the next 8 minutes of the show. The public defender. The office celebrates 25 years, I believe, this year. And the public defender was on Nationwide last week. Very good interview with Nationwide at 5 reporters, or host rather. And this is an area that JFJ, we've also made some recommendations around the public defender's office to the Constitutional Reform Committee. Now remember that the public defender is an interim act because it's awaiting its rightful place in the Constitution. Because when we talk about an office, an institution being placed in the Constitution, it's to ensure that it has greater levels of protection. So in other words, no political party can go to Parliament and use majority and just do away with a piece of legislation, because it would get at least entrenchment status, like the Director of Public Prosecution, the Auditor General, our Charter of Fundamental Rights and Freedoms. To make any change, you need a 2/3 majority at both the lower house and the upper house. So it has good protection. And both the Electoral Commission of Jamaica and the Public Defender awaits its rightful place in the Constitution. Now, when you read the Republic Amendment Bill, it does make provision for the ECJ to be placed in the Constitution, but there is no provision in the bill. It was in the Constitutional Reform Committee's report, but nothing on the public defender being placed in the Constitution in the Republic Bill. Now, what we have said here at JFJ in our recommendation, respectfully to the Joint Select Committee, is that we should ensure that the public defender go into the Constitution, but not with the basic roles and functions that it currently has. We have been articulating that we need the public defender to be transitioned into what we call a National Human Rights Institute. Some people will use the language National Human Rights Institution or National Human Rights Commission. And I think we need to have a full show on this topic one day, where we will explain to our listeners the importance of transitioning to a national human rights institution, because it will have greater powers. I heard the public defender articulating, for example, that she would love to see a legislation giving the office the power to impose sanctions. Very, very important. What we also may not be aware of is that the public defender, the interim act, it focuses primarily on the public defender having the powers to investigate your civil and political rights. And those are the earlier types of rights that we may have. So, for example, whether or not your right to due process were breached. If you recall, under the state of public emergency, the former public defender had done investigation about the detention of citizens who were under the SOE. But what we're saying is that the types of rights that would need to be investigated by the public defender need to be broadened from those earlier civil and political rights. Your right to vote in a free and fair election, that's a political right. To know more of your social and economic rights. As I said, listener, we need an entire show on this. But the point that I'm making is that we need the public defenders' powers to be broadened. We need the public defender to get more resources to do rights promotion. So, for example, I believe the public defender is not sufficiently resourced. You have, I believe, when you look at the budget that was tabled, the office gets less than $400 million per year. Compare that to other institutions that would be focusing, for example, on anti-corruption and so on. But this office that is so important in protecting our human rights, I don't believe is sufficiently resourced. The public defender has no jurisdiction when it comes to the JDF. And you know that, for example, you have the zones of special operations that will have both JDF officers and JCF officers doing joint task force. So you need that type of jurisdiction for the public defender. So I think we need an entire show on how we are promoting that the powers of the public defender be expanded and the office is strengthened. But for JFJ, what we have called for is that what is included in the Constitution under this constitutional reform process is the National Human Rights Institution. Very, very important. But as I said, an entire show on that particular topic, all right? But going back to the public defender, when she was speaking on Nationwide at 5, we welcome the opening of a Western office because we want to ensure that the office is accessible to as many Jamaicans as possible. So I'm happy to see the public defender more out in the media talking about the work of the office and some of the areas that require strengthening so we can see, an active body and people know that this is the office that they go to when their rights have been violated. I won't be able to discuss the topic another issue that came out in the media last week, which is the reduction in the ranking of press freedom, except to say that the Press Association and media practitioners, we must, when I say we, I mean you, I'm just using inclusive language, must pay attention to this. We saw a press statement coming from the PAJ. I think the press and the media fraternity, they need a sitting down on some of the utterances coming from the political directorate, the strength of some of the existing legislation. For example, the Access to Information Act, reviewed in 2010. There was a 2011 report not yet acted upon. So since that law was passed in 2002, it has never been amended. And, so I think we have some work to do there, but that's a discussion again for another day. But I do believe it was important to flag in terms of how do we ensure that our press freedom ranking improves and we don't see a decline again next year. So I think there needs to be a meeting of minds on some of the reasons that may have, or factors that may have contributed to that reduction, and ensure that we fix it as a society. Yeah. So as we close out, news commentator, it's your week again. We got an Instagram message, news commentator, that we should put you on suspension where you're not allowed to answer any more question. I don't think we will do that, but just to say that news commentator won, and we ratified the Convention of the Rights of the Child in 1991. All right? But we may have to put her on suspension going forward. So we'll see. But anyway, that's where we have to leave it. Thank you so much for your listening ear and your audience. We really appreciate it. And next week, we will meet again on Let's Talk Justice every Monday at 1 o'clock. My name is Michael Jackson, Executive Director of JFJ.
Jamaicans, for justice, the people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many, we are one in a Jamaica. Make it a better place for the boys and girls. Created equal by the creator. For equal rights and opportunities. No to unlawful detention and police brutalization. Class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or JamaicансForJustice.org.
The people's champion.
Reading is fundamental at Cozy Corner Books. We are your friendly neighbor.